Thank you, Mr. Chairman. I'd like to call out my amendment, Roberts Title IX, Amendment Number 1. It is also the same amendment that is co-sponsored by Senators Alexander and Enzi, and I thank them for their support. I know we have all monitored the impact of No Child Left Behind as well as the SEA. That's what we do, more especially the flexibility that we all want to achieve in behalf of our administrators and our teachers and our children. I'm concerned about a sidestep, this is my term, to congressional intent by offering strings-attached waivers to states. In September 2011, the Department of Education announced an ESEA flexibility plan that included 11 waivers of ESEA requirements, as well as 4 principles for, quote, improving student achievement and increasing the quality of instruction. Now, with the exception of one optional waiver, states would be required to apply for all 10 waivers and also agree to implement 4 principles that are developed by the Department of Education. Under Section 9401 of ESEA, I'm quoting, the Secretary may waive any statutory or regulatory requirement of this Act for a state education agency, local education agency, Indian tribe or school, if that entity receives funds and requests a waiver. However, it is evident that waivers have been granted only to those states that agree to implement the Department of Education's preferred education policies. The New York Times has referred to the waiver process, I'm quoting here, the most sweeping use of executive authority to rewrite federal education law since Washington expanded its involvement in education in the 1960s. The amendment that I have would amend Section 9401 to clarify that the waiver process is intended to be led by state and local requests, not Washington mandates. The process should be state-driven. It should allow for greater flexibility and innovation in accountability systems. In July of 2011, the CRS, the Congressional Research Service, issued a report providing overview of the Secretary's waiver authority under ESEA, and they warned of a potential legal limit and challenges to the Secretary's flexibility proposal. The report states, and I quote, if the Secretary did, as a condition of granting a waiver, require a grantee to take another action not currently required under the ESEA, the likelihood of a successful legal challenge would increase, particularly if the Department failed to sufficiently justify its rationale for imposing such conditions. Under such conditions, and I still am quoting, a reviewing court could deem the conditional waiver to be arbitrary and capricious or in excess of the agency's statutory authority. My amendment would prohibit the Secretary from imposing by regulation any additional requirements to waiver requests not authorized by the Congress. I don't think Washington has any business dictating to states and school districts what is best for the students they serve. And the example I would like to give of the federal overreach is best illustrated by Principle 3, there are 4 of them, but Principle 3 outlined by the Department in the waiver application. School and state leaders in my home state of Kansas are deeply interested in the principal and teacher evaluation process. I think every state is. I think every member here obviously is interested in that. My state has created a statewide commission. It consists of educators, school board members, representatives from education organizations and higher education institutions, all tasked with developing and adopting guidelines by this summer for teacher and principal evaluations. Now that, to me, sounds like a comprehensive state-led approach to designing a meaningful, robust evaluation system. However, the fact is that Kansas, in receiving only a conditional waiver, not a waiver, but a conditional waiver, demonstrates that the the Department of Education isn't only waiving aspects of current statute. Now, we have other examples. We have California. California was not willing to tie teacher evaluations to student test scores. That was a provision required by the Department of Education for receipt of a waiver. They said it is disappointing that our state's request, which enjoyed such strong support from parents, teachers, and administrators, education advocates all across California, has apparently been rejected of the denial for a waiver. And the Superintendent of Public Instruction argued that California's effort was in good faith. And they argued that a state's refusal to take the federal, quote, bait doesn't empower the department to then negotiate a superseding deal with its districts. The department should not bypass the state's constitutionally empowered education authority, overriding decades of precedent, and simply brush aside the intent of ESEA's accountability framework because the state didn't do what the Secretary wanted. Montana, Nebraska, California refused. Let me see if I can find the number of states that have asked for a waiver. 47 states and the District of Columbia and Puerto Rico and the Bureau of Education submitted requests for ESEA flexibility. All were obviously concerned about the overreach of No Child Left Behind and the effort to go ahead and get a waiver. Why, that's what they asked for. 37 states and the District of Columbia are approved. California is not, Texas is not, Kansas is conditional, Vermont submitted and then withdrew, North Dakota submitted and withdrew, and also Iowa. I know the chairman is fully familiar with that situation. So I am asking to that end for support of my amendment to clarify the Secretary's waiver authority. Right now, it's top down. I think it should be led by the local states and by local schools. I know we don't have a quorum, Mr. Chairman. I know this amendment will be put aside, for a vote.